not on record. Yeah, Mr. Clay, put on record.
We have been placed on record, I think.
Yes.
Yes. So we have instructions to, because that strike law, the man is satisfied that the man at the dock is one Koome Kirimi, unless he has a special leave to put a hood so that the country needs to see the biggest tip before the
Yeah, is that a necessary statement? Really?
Mr. Kashoka. Toa kofia, toa hood.
Yes,
Is that in order?
thank you.
However, we feel that that ruling has already been overtaken by events since the accused person has already been apprehended. Though the accused person is before you today, and the charge has already been registered, the DPP on 9th October this year did receive a letter regarding the accused person who is before you, reference charges trumped up against Mr. Kirimi Koome. The letter is from Hamdi and Company Advocates, and Article 157, Sub-Article 11, where the DPP is required to have interests of justice when charging I have instructions from the DPP to defer plea in this matter to the 17th October this year, that is Tuesday next week, so that the DPP will have gone through the letter vis-a-vis the evidence gathered by investigators to see whether the same will occasion a review of the decision to charge, which has already been arrived at. That application, Your Honor, is made in the interest of justice. There will be no prejudice occasioned on any party. Having regards that the substratum of this case, which are monies which have been frozen, will still be frozen on Tuesday.
Come again?
Up to Tuesday.
Come again.
The freezing orders
Yes.
are still in place before your Honorable Ehubi till Tuesday, 17th. So there will be no prejudice suffered on either party. Your Honor, having regards that the accused person has also been brought by warrants of arrest and is now a warrant of the court, we'll be getting directions of the court as to his status with regards to the warrants of arrest. The state prays that he be released on a cash bail. He is a flight risk owner, and we may not be able to bring him before the pre-court on Tuesday. That's all, Your Honor.
DPP to defer the plea. Save that the court should take notice that the letter is drafted from none of the counsels before you. And this is a continuous approach in this matter. Every time advocates are mutating. When that issue is resolved, the same advocate who was fired is in court. The DPP will also respond to that letter on behalf of our client, so that the DPP is apprised of the matters that are before this court. Now, secondly, warrants were issued he has been brought to court under police arrest. On this, we differ with the state. That a person who is arrested pursuant to a warrant must provide reasons as to why the warrant should be lifted and they be entered to Kashmir. It will be the norm in this country in courts that issue warrants of arrest. Taxpayers' money that has been used to trace him, arrest him, and arraign him here. Who meets that cost? With the burden of heavy taxation on Kenyans, their tax should be used prudently. Not somebody who does not respect the court, doesn't respect the police. So I have very firm instructions from my client to oppose the lifting of the warrants, to oppose him being entered into Kashmir. The investigating officer needs to take the doc on oath to explain to this court how risky and dangerous it was to trace the suspect, where they arrested him from. Those facts need to be brought to your attention, Your Honor. Kindly, Your Honor, protect the integrity of these proceedings as the DPP takes time to make a decision over the complaint. The judicial process under your guard and the instructions from my client were very clear warrants were not against an advocate. That even if you look at the judicial guidelines, policy guidelines, on parameters for one to be entered into cash bail, one, was he found in a manner, did he disobey lawful orders by the police? By not going to the police, the investigating officer needs to bring that. The pre-bail report needs to tell us whether he is fit to be released on cash bail. You know, the fact that the DPP has deferred plea taking under the control of the DPP or the police. He's your word. And the terms of releasing somebody on a warrant are very clear and settled. You know, it is my humble submission that for laundering or money laundering or illicit money, it is money for international merchants, MasterCard, Visa card, UBA Bank. All these, as Kenya is trying, the president is trying to bring this country into an international hub for business. Great international interest. You know, I believe I've convinced you. My good brothers from Shakahola will have nothing to tell you because they have already surrendered. I've seen from the notes here that they will not raise any issue. May you get favor in my submissions.
Your Honor, let me start by saying this. My colleague, Mr. Omari, is so articulate that he tries to use the president's position to try and blackmail you. This man bond, because the president wants to improve the economy. That president is not here today. That president does not know Koome Kirimi. They will never meet, perhaps in future. But right now, an application has been made to deny the accused person bond without any affidavit, without any documentation, without any formal application being made by either the prosecution or by the advocate watching brief. And if we are going to talk about law, let us start with that one. What do they have here? They have nothing. The prosecutor clearly, very clearly, has indicated to this court, at this stage, they have no objection to bail. That by itself means what exactly then? Means that he has spoken to that investigating officer that is being invited to the dog, means that he has spoken to the investigating team. And that means then they have reason to believe that the accused person does not need to be denied bond. So then what happens? Some person from Rwanda convinces my friend Omari here, please ask for the accused person not to be given bond. Somebody very busy out there. Remember, we were being called busybodies, but then we now know who the busybody would be. Based on what? It all simply then comes down to the law. And what does the law say? When an accused person or a suspect has been brought to court, he is entitled to bond. Unless the prosecution, I will repeat, unless the prosecution wants to object, and they shall give reasons. Mr. Omari, is he a prosecutor? Your Honor,
I almost became the deputy.
he almost became and they threw him out. But Your Honor, he is not. Maybe they fear him. It is the prosecution that is indicated there. That is the Constitution. Forget about the acts that brings in victims. That is the Constitution, the supreme law. Let us not try to circumvent it. And that one comes in under Article 49H or G. Those two. So then, you must then bring what you call compelling reasons. I will start with what my colleague has said, Mr. Omari. But probably my...
Come back for ruling at 2 p.m. Ruling at 2 p.m.